Welcome back. I've been joined in the studio now by legal practitioner Mr. Ehidiamen Destiny. He just been able to do justice to what the legal implications could be about the ongoing ministerial screening that's happening right now at the National Assembly. Good afternoon and welcome.
Good afternoon. It's good to be here again.
It's good to have you. So let's just start with, trying to educate people about what we're talking about. When people say incomplete ministerial list, they're wondering, we saw 28-man list, what's incomplete about that?
Okay, actually, my own grasp about those ministerial lists put forth by Mr. President to the National Assembly for screening is that it's unconstitutional. Prior before now, Nigeria governors, presidents, they have history. It has become their trademark of not sending forth ministerial nominees or commissioners for over a year or even 6 months. So in order to cure that mischief in law is like a problem. Section 149, that the president must bring in ministerial nominees 60 days upon swearing in. Now, as in this case, by this government of President Bola Ahmed Tinubu, he came into administration, he took the oath of office and swore to uphold the Constitution of Nigeria, 29th May 2023. Then, as of last week Thursday, it will reach the anniversary date of 60 days. You understand me? So in order to beat the time, he sent in 28 ministerial nominees, and that is at variance with Section 147 of the 1999 Constitution. The only thing that is allowed for the president to do is to at least send in 37 ministerial nominees from each of the state and the FCT. So if you look at, I think Bola Ahmed Tinubu, what he did is unconstitutional, is illegal.
Right, that's interesting when you put it that way. Well, let's talk about what the law really says in terms of when we read other laws and other stipulations. I think usually when there is something that must be done, there's usually some sort of penalty or some sort of something to fall back on when that thing is not done. What's happening now? Yeah,
even when I wrote it on my Facebook, people are saying, what is now the consequence if he fails to do so? But in fact, it is a constitutional provision. It must be upheld to this latter. If the court is to construe that session to its fullest, those ministerial appointments sent for by Mr. President is void.
That means the ones that will come
all
after.
No. The ones that will come after is void.
But those current ones that are safe. They
are safe. They are safe. The ones that will come after, they are void. It's an incomplete. Although people will say yes, it's at the discretion to sack a minister. At that time, since the constitutional 60 days have already passed, you still have a time free. But as it is now, if a party goes to court to challenge it, the person may get judgment in his favor. Because the Constitution says that you must send forth your ministerial nominees within 60 days upon taking the oath of office. And that constitutional provision also spread that you must appoint a minister from each. He must be an indigene of that state. That means of all the states in Nigeria. That means if you have out of 36 states in Nigeria, you must nominate a minister who is an indigene of that state and the FCT.
I guess this would speak to inclusion and being one and so on. But before we go into maybe other issues like the specific people that were on that list, there are some issues that people have in terms of where they are from and where the people from that state tend to be from in previous times. You mentioned FCT. Can we talk about that? We've been seeing agitations left, right, center. FCT original inhabitants keep saying that they never get that slot. Take for instance, as we currently speak, I'm actually not aware. Perhaps I have to do some research on that. The current FCT minister, I'm not aware if it's actually from FCT.
Okay. Let us just.
Before that, we had Rufai. We've had the former governor of, I think, is it Bauchi State?
Bauchi.
Yes. So we've been having different people come in here that are not from here, and they keep crying out that they are not getting that representation, and they don't seem to get any response or answer.
Okay. Before I I go down to that, I answer your question. Let me just explain what I was explaining that session. So that session again further says that section 147, which mandates a president to send forth his ministerial nominee within 60 days, that in each of the ministers at least there must be 10 women. It's like an affirmative action in that session that you must send in.
Please, can you take that again? You mean the ministerial list must have 10 women?
At least 10
women.
At least 10 women. You know, it must at least 10 women.
This is the constitution.
This is what is section 143, the new one, which is the 5th alteration, which was signed by President Mohamed Buhari at the penultimate stage of his presidency. Now again, there's a court judgment that recognizes Abuja as a state. So by the implication of that, is that the president must appoint a ministerial nominee who is an indigene of Abuja. Historically, if you check the people who have been ministers of FCT, Aliaro, Useni, there's one man from Plateau State, Useni, this man, Erufai, this one that just left now, the former governor of Bauchi, they are not indigenous of Abuja, and this has wreaked the Abuja people. It's as if it is insensitive. Let us be fair with ourselves. It is insensitive. We are not saying that the president must appoint an Abuja indigene as the minister of FCT. What they are saying, what the constitution is saying, that you must appoint a minister. You can appoint somebody who's an indigene of Abuja as Minister of Power or Attorney General. But the deliberate exclusion of Abuja indigene, that is what the Constitution, section 149, frowns about.
Right.
And that's what the president would have done, is to bring in at least 137 ministerial nominees from each of the 36 states and FCT, making it 37.
Well, interesting. I actually wasn't aware about the part about women. I wasn't sure about the particular. I thought it was just a case of, make sure women are there. I didn't know there was.
No. It was so specific.
All right, but I think previous governments seem to have also gotten away with that. Some of them anyway. And in this list,
yes. Just like what you say. What are the consequences? There is no consequence, but in law, or when interpreting the construction of a statute, it's what we call spirit and letters of that session. If the president breached that, the court can mandate him to do so. The court has the power, the inherent power, to mandate him to appoint at least 10 women in that position. That's what the law will do.
Yeah, it's interesting, really. I'm aware that some or a number of FCT and Abuja original inhabitants have actually won cases on this matter, but we're still yet to see implementation. But I'm speaking about that balancing. I think it was also a comment of yours I saw. Is there any sort of framework, even if it's not legal? Do you think there should be some sort of moral obligation in terms of the persons being picked from a state? I'll use Edo State, for instance. I believe you spoke on it, which is that for a couple of years now, or for the longest time, I believe, since Chief Tony Anene left, the Edo Central has not had a ministerial appointment. And, even in the state, ironically, they've not even had a chance at being governor since Governor Sumbo, who was removed after. In the
eyes of the law, he was not even a governor. If you look at it, interpret it legally, he was not even a governor, which means that since 1999, Edo Central has never produced a governor or even a deputy.
That's interesting. So, what is the way forward? I believe Pius Odubu was.
No, he's from Man was from Benin.
Okay, that's true. All right.
Again, it is the constitutional prerogative of the president to appoint. The law says that. The law doesn't say it must rotate among in the senatorial district. The law says pick one. So far, is an indigene of that state. If the person is even living in Sokoto all his life, but when he's signing form, but he holds himself and pride himself of indigene of a particular state where he's not residing.
Is allowed?
Is allowed. If you look at the people that made up Tinubu's cabinet, especially from the southwest, they don't even play politics in their various states. They play politics in Lagos. People like Dele Alake, Wale Odu. These people, they play their trip in Lagos, but they hold their self and pride themselves as an indigene of that state, not Lagos state, where they are doing their politics. So it is at the prerogative of the president to pick anybody he likes. He can even decide to be picking one family.
Sometimes people wonder, with the way the president entered, or the way he gained his victory, having a Muslim ticket there, some of the arguments or the talks then was that competence over identity, so to speak, but I guess there's no way around it when it comes to the ministerial list. But I'd like maybe if you can throw some light on it. President Buhari had 6 months, will I say, barren, without any ministers. What do you think about any actions or any policies made during this fallow period, or during this period where there is no actual minister? Does it count, or does it hold as much water? And truly, does the president really need a minister to make certain pronouncements, or is it just a case of making it easier for him?
The rationale for ministers being present in ministry is like a representative of the president in those ministry, so as to properly pilot the affairs of that ministry in the likes and the caprices of the president. It's just like the government, they want to be in charge of a particular ministry, the way to direct it for them to achieve their goals. That's the purpose of a minister being present in ministry. Normally, ministries, they are government, they are governments or government offices in perpetuity. Even as we speak now, they have permanent secretaries. Yeah. These permanent secretaries, they are employers of they are employees of that ministry. They remain there until they reach 35 years or 60 years, or they attain the age of 60 years.
Some people even say they're a bit too powerful.
Of course, they have to be powerful. Since there is no minister now, they are the alter ego of that ministry, permanent secretary. But when the minister comes, the minister is the president representative in their ministry. It's like the president overseeing that ministry. That's how it is. It's just like a university. You have VC, you have chairman governing, the pro-chancellor. The pro-chancellor is like the president representative in that school. The pro-chancellor is usually appointed by the president. So again, but to me, like what President Buhari did, waiting for 6 months, and so many other governors, even some governors wait for 1 year. It later became their trademark. They will not appoint a commissioner or a minister. So lawmakers, law framers saw this and decided to put it in our constitution, that 60 days upon taking the oath of office, you must appoint ministers or commissioner. It was to cure a mischief. Now, to me, there's even a lacuna. The lacuna is that if, for example, the ministerial nominees have been screened, there's no law that forced the president that you must appoint them, give them portfolio for the next 100 years or throughout your tenure.
Okay.
There's no law that says you must.
So you're saying this is something they could have exploited?
They could
in terms of maybe feeding people. He probably didn't intend to give portfolios just to meet that deadline,
which is not even properly met. So in my own estimation, so the law was going somewhere to cure a mischief. It was only finished halfway. If the law have, maybe the framers of that law know that, after sending forth the names of ministerial nominee within that constitutional time frame, which is 60 days, that once the Senate have screened them within the period of 21 days, which is in the constitution, they must screen them within 21. They must screen them within 21 days. Within 21 days, the constitution can also say, after 7 days, the president must attach a portfolio. That would be the constitution. Or to even make sense of the whole constitution of that section 144, if you are bringing forth the names of ministerial nominees, you must attach portfolio, so that relevant question will be in that ministry will be put across to that ministerial nominee, so as to test his knowledge, his dexterity in that area. Imagine making a lawyer the minister of a health. How will he perform? So if, for example, Mr. A is a ministerial nominee and the portfolio the president attached to it is a maybe the thing is science and technology, and this is a lawyer who has never done it relating to science and technology, the Senate, having the country's power, they can say no, this person is not qualified in respect of this portfolio that was attached to his name. You know, the constitution was going somewhere, but he did not finish. There's still a big lacuna. These two lacuna, time frame for it to give them, to appoint them as minister, and attaching portfolio to the ministerial nominee. Those are the two. One has been killed, but still remaining two.
Right, that's fair enough. Well, speaking of the issue of screening, I'd just like to know, you know, just for the sake of awareness, what are the levels or the extent to which the National Assembly can use its power? You know, I believe there were speculations about a certain person on that list, although I don't think his name has appeared yet, perhaps in the supplementary list. I'm talking about the Kano State Governor. People said there's a video of this man putting you know, dollars in his pocket, alleged corruption, and people say some persons have some kind of things attached to their name that they feel should make them ineligible to become part of the federal government or the cabinet. To what extent can the National Assembly say no, or you know, put a stop to these appointments?
The screening and the nomination of any ministerial nominee is at the whims and caprices of the Senate. If the Senate say no,
just the Senate,
yeah, maybe by a simple resolution, they don't like this person, or the question put across to that ministerial, the person failed or to give satisfactory answer, and it's a wisdom of the Senate, they said, oh no, this person is not fit to pilot any ministry in Nigeria. They can still pass a resolution that this person is not properly screened. He has not passed the test to be named. So the president does not have the capacity to nominate or appoint that person as a minister. This, to me, in the proper sense or in the proper semantic, they are just minister designates. Ministers designate. They are designated as minister. So they are here to cross the hurdle. So this is the biggest stage. This is the biggest hurdle they must pass before they can be set to be appointed as minister or given portfolio. All
right. To what extent or where does the issue of security bodies come in? People keep saying the DSS has to do its work, make sure you vet and all that. Where do they come in? Is that for the president? You know, do they do that and take it to the president? Do they do that, take it to the Senate? Are they just working independently? How does that really come in?
I said, when you want to nominate minister, even governors, want to commissioner, to do a security check to know the person you are appointing as a minister or as a commissioner, so that you don't end up bringing somebody who will undermine the security of the country. So it's just a rationale, and once is between the president and the security officer. The DSS is legally, statutorily, is directly responsible to the president under the National Intelligence, National Security Agencies Act, Section 3, is directly responsible to the president. So it is what they avail the president that the president will act on to nominate that person as a minister for the National Assembly to screen.
All right, well, we're aware that a lot of people are very versed in hiding things and so on and so forth. What happens after screening? Are there any legal processes when things begin to come up. Take for instance, there were allegations, numerous allegations. Some persons came with their versions of proofs and so on and so forth about a minister in President Buhari's tenure, talking about the Minister of Digital Economy and Communications and Digital Economy, Professor Issa Pantami.
Yeah.
And there were talks that he had ties with some terrorist links, or he made some comments that were not the best. When these things, assuming they are true or have any ounce of truth to it, whose does the onus lie on, if perhaps the president doesn't see anything wrong in it?
Oh, he who hire can fire. The president hire him.
What about the Senate? Do they have
no,
any
the
say?
Senate.
It's too late for them.
It's too late for them. Their power is circumscribed. Their power is only to screen a ministerial nominee. Once they pass that stage and they pass an approval for this person to be nominated as a minister, that ends it all. But with respect to your question, he who hire can fire. Even in interpretation act, that's how it is. He who hire can fire. If the minister begin to manifest conduct which is incongruous or incompatible with his office, and the nation, they complained, they can even complain through, even the Senate, the Senate can complain and advise the president to sack that person. But who does he like to sack a minister? It is the president. The president do the check and balance of ministers. So that's how it is. The president who hired them is the one that can fire.
This next question is, it's not, perhaps not really legal. Just like to hear your opinion.
Of course, it's legal. It's the president.
The next one I'm about to ask now. In fact, I've noticed it has happened it happens throughout the civil service. Some persons even say the head of the civil service of the Federation is so powerful that, she gets to decide, or her office gets to decide who goes where. We've seen permanent secretaries be shuffled. You see someone who has worked in the Ministry of Education for years suddenly being taken to perhaps something like Niger Delta Affairs. We saw it with a minister, the Minister of State for Environment, Dr. Sharon Ikiazo. She was with the Ministry of Environment. She has a reputation as a very, versed person when it comes to environment, climate, and so on, both in Nigeria and abroad. And then, once I think President Buhari sacked about 3 ministers, took the Agric minister to, the Environment minister to Agric, took this Minister of State for Agric to Minister of State for Environment to Niger Delta, took the one for what's it called, Health to Science and Tech, the one for Science and Tech to Environment. These are ministers being shuffled. What do you make of this? Really, is it really the most is this the optimum way to get performance when these people have been working with one portfolio for so long?
Okay, like you said, it's not a legal question. It's not. Let me just say my own opinion on it. Now, like I said, if you bring in forth a ministerial nominee or permanent secretary or a commissioner, make sure you put him in his element. If you put that person in the ministry where he can perform, which he has knowledge of, you can get the optimal performance from that person, the highest level, if I had good performance from that person. But if you put somebody in it, it's just like somebody who loves football, but you are forcing him to play hockey. You can't get the best out of him. It is when you put him to play football that you can get the best out of him. So that's why I say, in the amendment of that section 147, if you are bringing in forth ministerial nominee, even commissioner, attach portfolio to it, so that relevant question that will be put across to him will be centered around that field, and it is aimed at getting or know his depth of knowledge about that field which he is claiming to be, or which is also attached to his portfolio. As for ministry is like they are permanent secretary. They are like jack of all, master of all. You know, they just rotate among us. It's mainly administrative. It's mainly mainly administrative. Sometimes even civil servants, like lawyers in Ministry of Justice, they can work there, Ministry of Justice, later they will take them to Ministry of Agric. But they'll be working in that legal department. They're just, you know, moving around those government institutions. That's how it is. But in all what we are doing, we must put people in their element so that we can get the best performance.
That's fair enough. You know, I just have one question about, you know, just a curious one. When like you said, who has the power to hire
and to fire?
To fire. When ministers are fired, it should be that the minister replacing should be from the same region, right? The same state.
You know, you must read the constitution holistically. It says that you must bring forth a minister who is an EDG of that state. If a minister in one state is fired, the law behoves on the president constitutionally to send forth another minister who is an EDG of that state where a minister was sacked. Okay, if you say okay, somebody from Lagos, or let's say somebody from another state is sacked, and you say we should replace him with a minister from Lagos. Meanwhile, Lagos already have 1 or 2, which means I can sack other 37 and bring everybody from Lagos. Yes. So the constitution was state sensitive, regionally sensitive, to say once everybody, you must bring in a ministerial nominee from each of the states who is an indigenous of that state, or who is an indigenous of that state, and even the FCT. They are court authorities, judicial authority, classes of judicial authority that FCT is considered as a state. Therefore, they must produce a minister who is an EDG, not necessarily minister of FCT, but let that person be from FCT.
All right. You know, let me just squeeze in one last question. What does the constitution or the law say at all? Does it make any mention of ministers of states? Now people are complaining and they're saying, we want a lean government. You can't be spending so much and expecting masses to suffer, and yet you're having ministerial list of 40, 50 persons. So, is it constitutional?
What the constitution says, said at least.
No, but is there mention of ministers of states?
No, there's no minister of state in the constitution. But you know, the problem is that I was trying to paint this, you know, that there's still a lacuna. You know, it is at the discretion of the president to decide to design you. And I can say minister of state 1, minister of state 2. So far you are a minister. There's nothing like minister of state in the constitution. You know, that's how. Or maybe they are as best like assistant minister. But the president decides to designate them as a like, because the constitution empower him so.
All right, that's fair enough. Thank you so much, Mr. Adam in Destiny. It's a pleasure having you.
Oh, thank you very much. Thank you.
All right, that's all we'll take on this segment of the program. We'll bring you some more reports now. When we return, we'll delve into the issue of the Niger crisis and what Nigeria's part could be in resolving that conflict. Stay with us. We'll be right back.